Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Today we're bringing you a special bonus episode, brought to you in collaboration with the folks over at the Legal Writers Collective. Go on and check them out on our website or at legalwriterscollective.com. Hope you enjoy. The Queen and Smith. Court of Appeal for Ontario. Heard by video conference, September 24th, 2020. On appeal from the conviction entered on October 31st, 2012 by Justice Hugh K. O'Connell for the Superior Court of Justice. Reasons for decision. The appellant was convicted of aggravated assault arising out of a fight he and his co-accused, Paul Gallant, were alleged to have started with several strangers on March 4th, 2011. The appellant was found to have stabbed Anayat Thompson in the neck. The sole issue at trial was the identity of the assailants. There was no eyewitness identification, nor were the victims able to identify their assailants, apart from in-doc identification upon which the trial judge did not rely. The Crown's case centered on the testimony of the appellant's former girlfriend, Darlene McCoy, who testified that she overheard a conversation between the appellant and Gallant about the fight. Gallant gave a statement to the police and testified at trial. The appellant did not make a statement and did not testify at trial. McCoy testified that she received text messages from the appellant on the evening of the fight telling her that he had done something bad, that he was taking a cab home, and that he would tell her more when he arrived. She testified that after the appellant arrived, he told her to wash his clothes. He then shaved his head and beard. He told her that someone had thrown a beer bottle and nearly hit him in the head, that Gallant had hit someone over the head, and that he had swung at someone with his pocket knife. McCoy testified further that the appellant said he jumped a fence, ran to the hospital, and then called a cab. Gallant arrived at the apartment later that evening. McCoy testified that she heard the appellant and Gallant talking about the fight. She said that she heard the appellant say he thought that he struck someone in the face, and that Gallant said he had hit a man over the head with a pole. The appellant raises several grounds of appeal that focus on the trial judge's treatment of McCoy's evidence. In essence, the appellant renews the argument made before the trial judge that McCoy had a motive to fabricate and that her evidence was not credible. She was the appellant's former girlfriend and the mother of his daughter. Shortly after the stabbing, she became involved in a custody battle with the appellant. The implication is that she concocted the story in order to buttress her custody claim. The appellant argues that the trial judge erred by finding that McCoy was credible on the basis that she did not embellish her evidence, in violation of this court's recent decision in the Queen and Ali Saleh, 2020 ONCA 597. The appellant submits that the trial judge's finding that she did not embellish her evidence taints his credibility finding, and that it cannot stand as a result. We disagree. It is well established that the fact that a witness does not embellish her testimony does not enhance her credibility. But it is also well established that the mere mention of the absence of embellishment does not undermine a credibility finding that is otherwise properly supported. These points are made clear in Ali Saleh at paragraphs 16 to 17, a case in which the Crown conceded that the trial judge had improperly relied on a witness's lack of embellishment as an important factor to enhance her credibility, a concession this court accepted. This is not a case in which a witness's lack of embellishment was relied on or used as a make-weight to establish or enhance credibility. It was not inappropriate for the trial judge to note that McCoy had not embellished her evidence in the context of addressing the appellant's claim that she was merely reiterating press reports or that her testimony was led. Nor did the trial judge err by considering McCoy's testimonial demeanor. His credibility findings were not based on her demeanor. He simply referred to her candor and essential innocence in the manner she gave evidence. He cautioned himself not to rely on demeanor in determining the truth and stated specifically that he was not doing so. Ultimately, the trial judge accepted that McCoy had a motive to go to the police, but not a motive to fabricate her evidence. He found that she was credible after considering her evidence in the context of the evidence as a whole. The trial judge did not use Gallant's evidence impermissibly in finding that McCoy's evidence was corroborated. He was aware of the limitations on the use of Gallant's out-of-court police statement. He specifically stated that he had not used anything in the statement as direct evidence against the appellant or to corroborate McCoy's testimony. However, the trial judge was not prohibited from using Gallant's evidence at trial to corroborate McCoy's evidence, and his treatment of the evidence comports with the approach set out by this court in the Queen and Riley. The trial judge did not reject Gallant's evidence in its entirety, such that he was precluded from relying on some of the details of the evidence to corroborate McCoy's evidence. He rejected Gallant's alibi evidence, finding that his claim and his police statement concerned a different, earlier fight, was implausible and contrived. But he was entitled to use elements of Gallant's testimony at trial to find that there had been a fight, that the appellant was present, and that beer bottles were thrown. McCoy's evidence was also corroborated by the cab dispatch records and phone records. In summary, we are satisfied that the trial judge was alive to the issue concerning McCoy's testimony, including her pending custody dispute with the appellant as well as her having read press reports, both of which she acknowledged. He fully and fairly considered the evidence, including the evidence on reopening, in determining that she was credible. His decision reveals no error and is entitled to deference. Finally, we are satisfied that the trial judge properly considered the evidence as a whole and did not shift the burden to the appellant. He did not err in finding that the charge had been proven beyond a reasonable doubt. The appeal is dismissed. Appeal Justice P. Lowers, Appeal Justice Grant Huscroft, and Appeal Justice Harvison Young.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.